because it was illegal to do so, Exhibit P10 Alpha, authored by him, is conclusive that Nigerian Army Properties Limited was involved in ship berthing under the accused senior officer's watch. The special court-martial considers the denial as untrue and an afterthought. On the next element of having given instructions to Major S.A. Dauda to collect United States dollars in cash from ship owners to hand over to one Mr. Nee, Major S.A. Dauda testified before this special court-martial that he was given such instructions. Although the accused senior officer denied that he ever gave such instructions and that the officer did not work directly with him. However, other circumstantial evidence in this trial, as listed by the learned judge advocate in his sum-up, show beyond reasonable doubt that the accused senior officer gave the instruction that monies in United States dollars be collected from shipping companies who berth at the Nigerian Army Properties Limited jetty, situated at number 6 Marina, Victoria Island, Lagos, and handed to Mr. Nee. Prosecution witness 2, that is Major S.A. Dauda, testified that he complied with the instruction and over time collected a total sum of $1,045,400 United States dollars only, which is subsequently handed over to Mr. Nee, now at large, as directed by the accused senior officer. The court notes the statements and testimony of the accused senior officer that at the date relevant to this charge, when he was alleged to have given the verbal instruction for the collection of the monies in United States dollars cash to hand over same to Mr. Nee, he was on a special assignment and thus could not have met with a witness to have issued such instructions. This raised a defense of alibi, which the accused senior officer ought to have substantiated at the earliest opportunity. But the defense of alibi never came up at the earliest opportunity, including the period of investigation of this allegation. More so, the accused senior officer only set this court on prowl by saying he was not at the scene without details of his whereabouts at the time of commission of the crime in question. The court, therefore, based on the judicial authorities posited by the learned judge advocate, notes that the defense of alibi in the circumstances cannot avail the accused senior officer as an effective defense. On the last element of fraudulent taking, this court considered the testimonies of prosecution witness 2, Major S.A. Dauda, and prosecution witness 3, Major N. Usman, respectively, to the effect that the United States dollars they collected was for the use of Nigerian Army Properties Limited jetty, that the money collected hitherto for same purpose was paid into Nigerian Army Properties Limited domiciliary account at Unity Bank, but with the instruction of the accused senior officer for collection and handing over of the cash to Mr. Nee, cash deposits into the account ceased. Exhibit P2 Alpha, which is the statement of Nigerian Army Properties Limited Unity Bank domiciliary account number 00323-87221, shows that ship owners stopped depositing money into the account. There is no trace of the money collected and handed over to Mr. Nee. Hence, the most probable conclusion that they said Mr. Nee is that they said Mr. Nee was only used as a front by the accused senior officer to take the said sum of $1,045,400 United States dollars only, paid by Faltox Energy Resources Limited, thereby permanently depriving the Nigerian Army Properties Limited and by extension, the Nigerian Army of this sum of money. With these pieces of evidence, this special court-martial holds that the prosecution has proved all the elements of count 1 beyond reasonable doubt. The court, therefore, finds the accused senior officer, Major General U.M. Mohammed, N/8656, guilty as charged on count 1. Count 2, count 3, count 4, count 5, and count 6 will be taken together. These counts are virtually clones of count 1 and are similar and relate to allegations of collecting various sums of money in United States dollars cash from ship owners who berth their ships at Nigerian Army Properties Limited jetty, situate at number 6 Marina Victoria Island, Lagos, and the instructions to hand over the cash to one Mr. Nee, now at large. Owing to the common denominators of these counts, the particulars and elements of the offenses are similar, except for the recipients of the monies and the amounts involved. The pieces of evidence and documents tendered through the witnesses: Prosecution Witness 2, Major S.A. Dauda; Prosecution Witness 3, Major N. Usman; Prosecution Witness 9, Mr. Olawale Olaiwola; Prosecution Witness 10, Mr. Dave Olusheye; and Prosecution Witness 20, Alhaji Gbolahan Shakur Ijaoba, collectively reinforce one another to the extent of providing circumstantial evidence beyond reasonable doubt of these elements of the offense. The court therefore holds that in count 2, count 3, count 4, count 5, and count 6, the accused senior officer gave instructions to Major Usman, that is for count 2, count 5, and count 6, Mr. Gbolahan Shakur for count 3, Major Dauda for count 4, to collect monies in United States dollars cash from ship owners for the use of Nigerian Army Properties Limited jetty at number 6 Marina, Lagos. The defense of the accused senior officer to the allegations as in count 1 is also that Nigerian Army Properties Limited under his watch did not engage in ship berthing services, since it was illegal and he could not have engaged in an illegality. The court, reaching to this decision as in count 1, is that Exhibit P10 Alpha is an admission by the accused senior officer where he stated that Nigerian Army Properties Limited was involved in ship berthing services while handing over the management of Nigerian Army Properties Limited to his successor, Major General A.A. Adesope, who was Prosecution Witness 24 at this special court-martial. The court therefore adopts his holding in count 1 and applies same in count 2, count 3, count 4, count 5, and count 6. Accordingly, this special court-martial holds that the prosecution proved all the particulars and elements of count 2, count 3, count 4, count 5, and count 6. Consequently, the court finds as follows: the accused senior officer, Major General U.M. Mohammed, N/8656, is guilty as charged in count 2. The accused senior officer, Major General U.M. Mohammed, N/8656, is guilty as charged in count 3. The accused senior officer, Major General U.M. Mohammed, N/8656, is guilty as charged in count 4. The accused senior officer, Major General U.M. Mohammed, N/8656, is guilty as charged in count 5. And the accused senior officer, Major General U.M. Mohammed, N/8656, is guilty as charged in count 6. Count 7. Statement of offense. Committing a civil offense by virtue of Section 114, subsection 1 of the Armed Forces Act, Cap A20, Laws of the Federation of Nigeria, 2004. That is to say, criminal conspiracy to commit forgery, contrary to Section 96, subsection 1, subsection alpha of the Penal Code, Laws of Northern Nigeria, 1963, Cap 89, and punishable under Section 97 of the Penal Code, Laws of Northern Nigeria, 1963, Cap 89. Particulars of offense. In that you, Major General U.M. Mohammed, N/8656, on or at about 11 June 2018, while serving as the Group Managing Director / Executive Vice Chairman of Nigerian Army Properties Limited, conspired with one Mr. Yusuf Abubakar Abdullahi, now at large, who at the material time was the company secretary and legal advisor to Nigerian Army Properties Limited, to forge a document titled Board of Directors Resolution, dated 11 June 2018, directing the opening of a domiciliary account for Nigerian Army Properties Limited in Unity Bank PLC. Elements of the offense. The elements of the charge in count 7 are as follows. 1. That the accused senior officer is subject to service law. 2. That on or about 11 June 2018, he was serving as the Group Managing Director of Nigerian Army Properties Limited. 3. That while serving as the Group Managing Director of Nigerian Army Properties Limited, he forged a document titled Board of Directors Resolution, dated 11 June 2018, and that the said forgery was done in conjunction with one Mr. Yusuf Abubakar Abdullahi. This is a count of criminal conspiracy, criminalized under Section 96, subsection 1, subsection alpha, and punishable under Section 97 of the Penal Code, Laws of Northern Nigeria, 1963, Cap 89. Gleaning from the advice of the learned judge advocate, conspiracy means an agreement between two or more persons to commit an offense or do something which in itself is not an offense, but through illegal means. The gist of the offense is in the agreement to commit the offense and not the proposed offense itself. The offense of conspiracy is therefore independent of the proposed offense. Thus, anyone alleging the existence of a conspiracy, in this instance, the prosecution, must provide evidence beyond reasonable doubt of an agreement between the parties. Proof of the substantive offense does not necessarily translate to proof of any underlying conspiracy. In the instant count, the prosecution concentrated all its efforts on the attempt to prove the substantive offense without leading a scintilla evidence to prove the alleged offense of conspiracy. This special court-martial, therefore, resolves this yawning lacuna in favor of the accused senior officer. Consequently, the accused senior officer, Major General U.M. Mohammed, N/8656 is not guilty